Okay, next up we have Georgiana, is it Bear? Please be seated. All right, and these are case numbers 24 TRC 2994, 24 CRB 438, both captioned the State of Ohio versus Georgiana Bear. She's here with counsel, Mr. Luppman. We have Ms. Richter here on behalf of the City of Johnstown, and we're here for the purpose of a change of plea and sentencing. Is that correct, Mr. Luppman?
That is, Your Honor.
And my understanding is that, let's see, we've got the OVI charges on the traffic matter. We have both the A impaired and the refusal with a prior within 20. And then we also have in the criminal matter, let's see, resisting and disorderly. My understanding is that she's going to be entering pleas of no contest to all the charges, Mr. Luppman?
That's correct, Your Honor.
And is that true, ma'am?
Yes, sir.
And before I can accept your pleas, you've already watched and seen that I'm going to be required to ask you some questions. Do you realize, of course, that you're not required to plead guilty, nor can anybody force you to do so?
I do.
Do you understand that you're presumed to be not guilty of everything, and the state has to prove every essential element of each offense beyond a reasonable doubt in order for you to be convicted of that offense? Did you know that you have a right to have a trial with a judge or a jury?
I do.
Did you also understand that you would have the right at that trial to cross-examine your accusers?
I do.
There's some tissues on the table. Feel free to utilize those. You would also have the right to subpoena your own witnesses to compel their attendance at the trial. Did you understand that?
I do.
And did you know that you would not be required to testify at trial, that nobody could force you to, and the decision not to testify couldn't be held against you in any way?
Yes, sir.
Now, a plea of no contest is not a complete admission of guilt. In fact, it's not an admission of guilt at all. The plea itself cannot be used against you in any later civil or criminal matter. Do you understand all of that?
I do.
Now, a no contest plea does mean that you're agreeing that the facts alleged against you are true. And if those facts are sufficient to sustain these charges, I will enter guilty findings. Do you realize that?
I do, sir.
And Mr. Luppman, is there a stipulation? You know what? I just read a case on this. It just came out in the O-Bar. I'm going to go ahead at this time and, let's go over.
And if I may, Your Honor, with respect to dealing with it, I would stipulate finding guilt if, in terms of reading the facts, if that's going to go and change something, where that might be going, we could certainly go and just enter a guilty plea as opposed to a no contest plea if that's going to go and change that.
Well, if you want to do a stipulation as to a finding of guilt, then I'll accept that.
I would.
Okay. So what that means.
To be very clear, stipulate a finding of guilt, Your Honor.
Yeah. So what that means is, Ms. Baird, not only are you agreeing that the facts are true, you're conceding that the facts are sufficient to sustain a conviction. Do you understand?
Yes, sir.
All right. Now, if I accept your pleas and enter convictions here today, I am going to impose sentence upon you. Now, you've been charged with two different theories of OVI. One being that you were too impaired to drive. The other were you too impaired to drive, refused to submit to a chemical test, and you have a prior OVI conviction within 20 years. In that circumstance, the state gets to pick which one I'm going to enter a conviction and sentence on, but I will only be entering one conviction and one sentence. Ms. Richter, on behalf of the city?
A2.
So the state's elected to pursue the refusal charge. That is a misdemeanor. It's unclassified. Was it second and 10?
I think the third
and 10
is
refusal?
unclassified. This is still a first-degree misdemeanor, Your Honor.
I have in my notes from our pretrial from May, second and 10 refusal and third lifetime.
That's what I have.
Okay. So as a second offense within a 10-year period, the maximum penalties that you face are up to 180 days in jail, up to a 7-year license suspension, and a maximum fine of $1,625. Any questions about that?
No, sir.
At a minimum, the court is required to fine you not less than $525, suspend your license for at least 1 year, and send you to serve 20 consecutive days in Licking County Jail. Normally it would be 10, but the refusal serves to double any mandatory minimum jail term, so that's why it's 20 in your case. Do you understand?
Yes, sir.
All right. The resisting arrest charge, that's a misdemeanor of the second degree, carrying up to 90 days in the county jail, up to a $750 fine. And on the disorderly conduct charge, that's a fourth degree misdemeanor. That's up to 30 days and a $250 fine. Do you understand all of that?
Yes, sir.
Ms. Bair, have you been subjected to any threats, promises, or offers of reward, or any other improper inducements to get you to change your pleas or to waive your rights, or to stipulate to a finding of guilt?
No, sir.
Are you currently under the influence of anything right now?
No, sir.
Are you satisfied with the advice and representation that you've received from your attorneys?
Yes, sir.
And are you a citizen of the United States of America?
Yes, sir.
And I find that your pleas and your stipulation and your rights waivers have all been knowingly, intelligently, and voluntarily made. I'll accept those the pleas. I'll enter convictions on everything except for the OVI impaired. Mr. Luffin, would you care to make a statement of mitigation on behalf of your client?
I would, Your Honor. Obviously, I had the opportunity to go and present the court. Hopefully, you had the opportunity to review that prior to being here. Ms. Bear has gone and gotten the assessment through LAP. She has gone and been to 2 in-person counseling sessions. She's been doing tele-counseling sessions, and she just recently went and did a full day treatment program there as well, and is going to continue to do that. I know how important the court takes treatment and going and trying to get a handle of potential issues, and I think certainly, there's a very realistic argument and assessment backing that up with, a second offense in 10 years and obviously a third lifetime, that there are some issues to go and work through. I think also, potentially for her, she's gone and really grasped that and is going and trying to be proactive and trying to lead a sober lifestyle. And obviously, again, realizes the gravitas of the situation, where it's gone and put her in terms of being here and the potential penalties the court can enforce. Potentially when the events were happening, there were some medical issues, but at the end of the day, again, she knows where she's at and what she needs to be doing. And I think that she's making a genuine effort to go and improve on herself and obviously lead a sober lifestyle. So I just want the court to be aware of that. Obviously, we provided the court with documentation thereof. Otherwise, Your Honor, Ms. Bear is 48 years old. She's lived a pretty outstanding life. Otherwise, she's been doing program and project management for 25 years. She informed me today that she's been working with Cardinal Healthcare. She just received a promotion, so she's increasing in her work volume and what she's going and doing. She's got a blended family. She's married with 5 children and 2 grandchildren, and she does all sorts of, she's doing community service. She's just active in the community and also with her family. So obviously, again, in terms of going and dealing with this and moving forward, I know that the mandatory minimum penalty, obviously statutorily, is 20 days. I would be remiss if I didn't request, though I know that certain findings need to be made in order to potentially go and do that, that there is an alternative sentencing of 10 days in jail and 36 days of electronic home monitoring. I would submit to the court that given Ms. Bear's genuine effort in terms of going and getting counseling and doing the other things that she's done, that she might be a good candidate to go and do that, and if the court would consider going and doing that, an alternative would certainly appreciate it. Alternatively, if that's not something that's permissible, she's indicated that she would seek an enforcement date for tomorrow, as she would like to go and try to put this all behind her and move forward with her life. Obviously, again, having the opportunity to see her, I would hope that the court would find that she is genuinely remorseful for being here, and again, obviously, this has had a huge impact in her life. Nothing further.
All right, thank you, counsel. Ms. Bear, you have a right to make a statement before the court passes any sentence here today, but you're not required to. Is there anything that you'd like to say?
I'm sorry that circumstances put me in a situation that I'm in and that I was a part of that. And I'm also very sorry to the folks that had to deal with the circumstances that day. I did reach out to the officer arresting the very next day after this occurred, letting him know that I was very sorry that I put them into these particular circumstances to have to deal with me when they had other things that they could have been dealing with. So again, I'm sorry.
All right, thank you, Ms. Bear. Ms. Richter, did the city wish to be heard regarding the matter of sentencing?
Your Honor, I would defer to the court. I would just note, though, for the purposes of the record, that the disorderly conduct in this charge is a result of Ms. Bear's actions inside the store prior to the police showing up. And I did speak with the 2 witnesses, which I would consider the victims under Marcy's law in that case. They're fully aware of the plea. They're on board with it, and they just wanted to get help.
Fair enough.
They were actually very concerned about her that day, and I think that's kind of how it started, them trying to tell her to use help, and then it escalated, so.
All right, thank you very much. All right. Baehr?
Correct.
So, it looks like you, obviously you were arrested and taken to the jail, but you posted bond. Was it later that morning,
It was the next day, it's, I wanna say 7:30.
AM?
Yeah, I was in the hospital for like 5 hours in between all of this, and when they took me, I wanna say it was probably around 1 o'clock in the morning. And I posted around, I wanna say 7:30-ish.
Okay. All right, well, I'm not going to sit here and lecture you, Ms. Bear. Obviously, you are much more familiar and intimate with the issues that you're dealing with. I always point out the fact that I'm no clinician. I don't have the expertise or the credentials to diagnose anybody. But somebody once told me what I consider to be about the best way to define that, and that is if something causes you a problem, it is a problem. This is your third go-around, second within the last 10-year period. And you're in a courtroom, you're facing deprivation of your liberty, significant financial sanctions, the stigma of conviction. It's probably getting to the point where you're going to make a decision to go one way or the other. It looks like you made an early commitment to maintain your sobriety and ultimately achieve a life of recovery, which is certainly very possible. People get better, and if you have been diagnosed, you know, substance abuse disorder is just that. It's a disease. It's not a character flaw. And I could no more blame you for having a disease of substance abuse disorder if in fact that were to be diagnosed than I could if you had a bad heart or cancer. That's not your fault. What I can hold you accountable for is not treating it. And so, you know, you don't need to worry about next week or next month or anything like that. You need to worry about the next 8 hours basically, and then you can worry about tomorrow. And I think if you just put one foot in front of the other, by the time you're well on your way, you're going to look back and realize how far you've come. But it'll be a lifelong journey if you're going to maintain your sobriety, because that's an incurable condition, but it is very treatable. So, that being said, the court is going to impose a 180-day jail term and suspend 160 of the days. I'm going to give her credit for the time that she was in jail. I'll give her a day worth of credit there. It'll be a one-year period of probation. Obviously, no drinking, no drug use, no abuse of prescription medication. If DLAP didn't do it, and I didn't have a chance to look all the way through that, but I did verify that in fact she'd been assessed, so that's good. If they did not do a mental health assessment, I'm going to order that you undergo one of those as well, because if there are issues in that regard, you have to deal with them both simultaneously, or you won't deal with either of them successfully. So you'll talk